Mr. Golding apologizes. And Mr. Charles Sinclair, Senator Charles Sinclair. And Senator Knight will miss the profound interventions, but we can proceed. You have the minutes circulated for this. When I look at that today, I will just move on to their presentations. It's the first time we're doing minutes.
We didn't confirm the others either, so.
Yeah. No, we'll move into the minute. We'll have to do the confirmation minutes at another stage. We didn't confirm the others. All right, today we're pretty near the end, but we have two submissions here. One from the Ministry of National Security and one from the Jamaica Constabulary Force. I gather the one from the JSC will be done verbally, right? So you want to take that first?
Yes, Mr. Chairman.
All right.
Good afternoon. Good afternoon, Mr. Chairman, and to your members. My contribution today is concerning the proposed regime of the pre-charge detention period that the JCF had proposed as a possible amendment to the Act.
Just as a point of order, could you introduce yourself and especially not just for us but for the Hansard writers?
Certainly.
Your position.
An unusual member of the JCF, so I think you should know her name.
Good afternoon again. My name is Alethea White, and I'm the Director of the Legal Affairs Division at the Jamaica Constabulary Force. Now, one of the proposals that the JCF made for the amendment was to be able to detain persons suspected of committing offences under the Act for a maximum of 14 days without charge. And that was one of the recommendations that caused a bit of unease, let's say, by the members. There was concerns as to whether this would be a breach of their constitutional rights. And I believe it was Member Golding who had suggested that perhaps it would be helpful to see some kind of draft regime that could be incorporated to ensure that there are adequate safeguards for the protection of persons' rights and liberties. So in that regard, I did research, and in conducting my research, the primary legislation that kept coming up was that of the United Kingdom Terrorism Act. Now, I go into that on page 2 of my proposal, and I think that act is useful to examine because that act allows the police to detain a person suspected of terrorism for up to a maximum of 28 days. However, the detention is subject to a strict regime of judicial intervention and reviews. And that is the act that I saw actually incorporated in a schedule to the act, the different safeguards that are in place and the different procedures. So in examining that act, I found that under Part 3 of Schedule 8, which is the schedule that deals with the detention, it provides for a procedure of review of the detention. Now, it provides that within the first 48 hours of a person's detention, there should be a review officer who should review the detention. Yes, within 48 hours. The first review, however, should be carried out as soon as is reasonably practicable after the person is arrested, and subsequent reviews must take place at least every 12 hours, at 12-hour intervals. The review officer should only authorize the person's continued detention if he is satisfied of certain factors, and the factors are laid out in the schedule. Some of the factors include that the person's detention is necessary to obtain relevant evidence, whether by questioning him or otherwise, to preserve relevant evidence, and pending a decision of whether he should be charged. Now, the review officer must also be satisfied that the investigation in connection with which the person is being detained is being conducted diligently and expeditiously. Now, the schedule also provides that the review officer must be an officer who is not directly involved in the investigation. The review officer can be, however, an inspector if it is conducted within 24 hours. However, any subsequent review up to 48 hours, the review officer must be a superintendent. So the more time that is the person is being spent in detention, the higher the rank of the officer that must review it. The review officer is also mandated to give the person detained or his attorney at law an opportunity to make representations about the detention before he makes his decision of whether to authorize the detention. And he is also mandated to make a written record of the outcome of the review, which should include the grounds upon which the continued detention is authorized. Now, if the police want to detain a person beyond 48 hours, the discretion to do so is taken away from that review officer, and now it's put with a judicial authority, because the police have to apply for a warrant from a judicial authority if they want the continued detention extended. And in England and Wales, the judicial authority means district judge of the magistrate court. The application for the warrant cannot be heard unless the person detained has been given notice of the application and the grounds upon which the warrant is sought. The person detained must also be informed of the time that the application is to be heard. Now, the judicial authority can only grant the warrant in the first instance for a period of 7 days, beginning with the date of the person's arrest. And he can only grant the warrant if he is satisfied that there are reasonable grounds for believing that the further detention is necessary. And again, they have a list of factors that he must be satisfied of. Some are that to obtain relevant evidence by questioning him or to preserve relevant evidence. He again must also be satisfied that the investigation is being conducted diligently and expeditiously. The person detained or his legal representative is given an opportunity to make either oral or written representations to the judicial authority and is entitled to be represented at the hearing. However, the judicial authority has the power to exclude the person detained and his representative from the hearing and to withhold specified information from the person in certain circumstances. And these circumstances are where the judicial authority is satisfied of different factors. Some of the factors include that the evidence of an offense would be interfered with or harmed if the person detained is informed of the information, or that the recovery of property would be hindered, or that the apprehension, prosecution, or conviction of a suspect would be made more difficult from the person being alerted. So there are a set of circumstances which empowers the judicial authority to exclude the person detained from the hearing. Now, the regime also allows an application to be made for an extension or further extension of the period specified in the warrant for further detention, and that is this application should be made to the judicial authority where the detention would be up to 14 days. If the detention is going to go up to 28 days, which is the maximum, that application has to be made before a senior judge. Now, the regime under the Act has been tested in the European Court of Human Rights against Article 5 of the European Convention on Human Rights, which guarantees the right to liberty and security.
If detention is to exceed 28 days, you go to a senior judge?
If the intention is to exceed 14 days, it goes to a senior judge.
You go to a senior judge?
Yes. And the senior judge can only authorize up to 28 days from the initial arrest.
Okay.
Yes.
So the initial is 4 days, then 40, you go before a district judge.
The initial arrest is 48 hours first with the reviewing officer's discretion. Right. Then after the 48 hours, the police have to go to a judicial authority, which is like a district court judge. Right. And that district court judge can grant, in the first instance, up to 7 days. Then in the second instance, up to 14 days. And
that would be equivalent to a parish judge?
Yes.
Right.
And then if you want to go above the 14 days, you have to go to the senior judge, which would be equivalent to our Supreme Court judges.
A Supreme Court judge? Up to
28 days, yes. But we are only proposing 14 days for our purposes. Right, the regime was tested in the European Court of Human Rights when looking at Article 5. So I can just go through Article 5 because I thought that it was similar to our charter in terms of what is provided for the right of liberty. Now, Article 5 states, everyone has the right to liberty and security of person. No one shall be deprived of his liberty save in the following cases and in accordance with a procedure prescribed by law. C, the lawful arrest or detention of a person effected for the purpose of bringing him before the competent legal authority on reasonable suspicion of having committed an offense, or when it is reasonably considered necessary to prevent him committing an offense or fleeing after having done so. Everyone arrested or detained in accordance with the provisions of paragraph 1C of this article shall be brought promptly before a judge or other officer authorized by law to exercise judicial power and shall be entitled to a trial within a reasonable time or to release pending trial. Release may be conditioned by guarantees to appear before trial. Now, when one looks at that in conjunction with our section 14 of our Charter of Rights, we can see that they're similar in nature. Now, our section 14 states, no person shall be deprived of his liberty except on reasonable grounds and in accordance with fair procedures established by law in the following circumstances. F, the arrest or detention of a person for the purpose of bringing him before the competent legal authority on reasonable suspicion of his having committed an offense, or where it is reasonably necessary to prevent him committing an offense. Any person who is arrested or detained shall be entitled to be tried within a reasonable time and shall be brought forthwith or as soon as is reasonably practicable before an officer authorized by law or a court, and released either conditionally or upon reasonable conditions to secure his attendance at trial or any other stage of the proceedings. Or if he is not released, as mentioned in paragraph A2, shall be promptly brought before a court which may thereupon release him as provided in that paragraph. So both provisions provide for arrest and detention on reasonable suspicion of having committed an offense and to prevent the committal of an offense. And both provisions require that you bring the person either to a judge or an authorized officer, or an officer authorized by law. So because of that similarity, I looked to see cases in which the regime under the UK Terrorism Act was tested. And one of those cases is the case of Mackay against the United Kingdom. And in this case, the European Court of Human Rights, by a majority, held that there was no violation of the convention and noted that the regime complied with the requirements of the convention. The court noted three primary features that a detention regime must have in order to be compatible with the convention. Now, the court noted that case law establishes that there must be protection of an individual arrested or detained on suspicion of having committed a criminal offense through judicial control. The judicial control must satisfy the following requirements. The first was promptness, that the judicial control on the first appearance of an arrested individual must above all be prompt to allow detection of any ill treatment and to keep at a minimum, any unjustified interference with liberty. The third feature is automatic nature of the review. The court noted that the review must be automatic and cannot depend on the application of the detained person. A person subjected to ill treatment might be incapable of lodging an application asking for a judge to review their detention. So it must be something that is done automatically. The third feature was the characteristics and powers of the judicial officer. Court noted that the officer must offer the requisite guarantees of independence from the executive and the parties, and he or she must have the power to order release after hearing the individual and reviewing the lawfulness of the detention. So it really requires the judicial officer to assess the merits of the detention. Now, the regime under the United Kingdom Terrorism Act was also tested in the case of the Queen on the application of Share and others against Chief Constable and Greater Manchester Police and others. Now, here the court gave a summary as they understood it of the regime. It stated, in short, a person arrested under the Act on suspicion of being a terrorist can be detained for 48 hours without charge. Such detention to be subject of periodic review by a senior officer. If the police wish to extend that period of detention without charge beyond the 48 hours, they must apply to the district judge for a warrant of further detention. A period of detention can be extended by the district judge for up to 7 days at any one time, but not for more than 14 days in total. If the police wish to extend the period of total detention to more than 14 days, an application has to be made to a high court judge. The absolute maximum period of detention without charge in these circumstances is 28 days. The court also thought it important to note a decision of the House of Lords in Ward against the Police Service of Northern Ireland, where Lord Bingham said of the regime that it enables a constable to arrest without warrant a person who he reasonably suspects to be a terrorist. The length of the detention that may fall on such arrest is the subject of carefully constructed timetable. This timetable, in its turn, is the subject of a series of carefully constructed procedural safeguards. Now, the court also noted that there will be circumstances where the person who is detained or his representative should not be present, and certain information can be excluded, not be given to them. In that regard, they noted that it was unlawful to exclude a terrorist suspect and his legal representative from an extension hearing so that the judicial officer could explore in sufficient detail whether the test for further detention is satisfied. The procedure before the judicial authority, what the procedure contemplates is in the interest of the detained person. That's what the court said. That is in the interest of the detained person and not the police, even though one would think it's the other way around. They said that because it recognizes that the sensitive nature of the inquiries the judicial authority may wish to be satisfied in that person's best interest, that there are reasonable grounds for believing that the further detention being sought is necessary. The judicial authorities need to scrutinize, may trespass upon the right of the police to withhold from a suspect a line of questioning they intend to pursue when he's being interviewed. If it does, it will not be to the detained person's disadvantage for him to be excluded, so that the judicial authority may examine that issue more closely to see whether the exacting test for an extension is satisfied. The power will not in that event be being used against the detained person, but for his benefit. So here they are justifying the ex parte applications and the situations where the person should be excluded. Now, they noted that the world has changed and Parliament has deemed it appropriate in certain circumstances for persons to be detained without charge for that sort of period. The provisions of the Terrorism Act, as analyzed in the case of Ward, are designed to ensure proper safeguards for the liberty of the citizen in such circumstances. So in both cases, they upheld the legality and validity of the regime under the Act. And in those circumstances, I think that the Act and the procedure under it can serve us as a useful guide in developing our procedure. So taking that into consideration, I developed a proposal for what the procedure could look like. Now, the first thing I noted in the procedure is that a person suspected of committing an offense under the Act can be detained without charge for a period of 7 days at first, but this period can be extended for up to an additional 7 days by a parish court judge. During the period of the initial 7 days, the person's detention must be periodically reviewed by a justice of the peace. So I noted that under the UK Act, the review officer was a police officer, inspector first, and then superintendent. But I was of the view that while this might satisfy the requirement for independence in the UK, it might not satisfy the requirement for independence in our local context, given the feeling of distrust that some members have towards members of the police. So in that regard, I submitted that the use of a justice of the peace would be appropriate. And I noted that provisions have been made for justice of the peace to be given judicial authority in many of our statutes, such as the Bail Act and the Constabulary Force Act. So this shows that Parliament is confident in the independence and capability of justice of the peace. So the proposal is for a justice of the peace to be the reviewing officer for that initial 7 days. Now, I'm also proposing that the review must be conducted every 24 hours by the Justice of the Peace. I note that under the UK Act, it provides that the review must take place as soon as is reasonably practicable, and subsequent reviews must take place every 12 hours. However, I am submitting that 24 hours is still a reasonable time and still satisfies the requirement of promptness. I am concerned that 12 hours might not be sufficient time for the police to properly progress their investigations, and that 24 hours provides a sufficient balance between giving the police the time to progress their investigations and ensuring that the review of the person's detention is conducted within a reasonable time. I'm also noted that the period of 24 hours is in keeping with our Bail Act. Section 22 of the Bail Act provides that where a person who is arrested or detained is not charged within 24 hours, then he shall be brought before a parish judge or justice of the peace, who shall order his release or make such other order as he thinks fit. So that is the justification for the 24-hour review instead of the 12-hour review under the UK Act. Also proposing that the 24-hour review be automatic, as was noted in the cases. That is a required feature, so it must not depend on any application of the detained person. So with a system, therefore, needs to be established that brings the matter to the attention of a justice of the peace every 24 hours. Perhaps it can involve the justice of the peace attending upon the police station every 24 hours, or the police attending upon the justice of the peace every 24 hours. So that system would have to be worked out to ensure that it is automatic. The person detained must be given notice of when his detention is going to be reviewed and the grounds upon which the police are relying to review his detention. However, this will be subject to certain circumstances where he can be excluded and the material need not be given to him. The person detained or his representative must also be given an opportunity to make representations before the justice of the peace, as if they desire, at each occasion that the person's detention is being reviewed. At each review, the justice of the peace will have the power to authorize the detention or to release the person. And the justice of the peace should only authorize the detention if he is satisfied of certain factors. And he must also be satisfied that the investigation is being conducted diligently and expeditiously. And I'd recommended that we look to the Act to see some of the factors and try to incorporate those in our proposal. Now, the justice of the peace should only, he will only have the power to authorize detention for up to 7 days. And now, if the police wish a longer period, they will have to go to a parish court judge. Now, an order for detention granted by the parish court judge can only be for a maximum of 14 days in total. So it can only be for a maximum of 7 days from the date they granted the order, making it a total of 14 days for the person since his initial arrest. Now, the parish judge should also have the power to refuse the application and order the release. And the person detained must be given notice of the application and be allowed to make representations and be legally represented at the hearing. And the parish judge, again, should only grant an order for the person's continued detention if satisfied that there are reasonable grounds for believing that the further detention is necessary in certain circumstances. Now, I propose to impose that standard of reasonable grounds for believing at this stage, which is a higher and more objective standard than what is imposed at the review stage for the justice of the peace. What is imposed at the review stage for the justice of the peace is that he be satisfied. But the standard of reasonable grounds for belief is a more objective and higher standard, because as the period of detention continues to be longer, the standard should be raised. Now, even though it's a higher standard, it's not one that requires proof to any civil or criminal standard, as that would not be required at this stage of investigation. Now, I made reference to a Privy Council decision, that of the Assets Recovery Agency ex parte Jamaica, where the standard reasonable grounds for believing was discussed. And in that case, the Privy Council noted that reasonable grounds for believing a primary fact do not involve proving that the person has done such a thing, whether to the criminal or civil standard of proof. The test is concerned not with proof, but with existence of grounds or reasons for believing or thinking something, and with the reasonableness of those grounds. The test does not ask for the primary fact to be proved. It only asks for the applicant to show that it is believed to exist and that there are objectively reasonable grounds for that belief. It imposes a well-understood objective standard of which the judge is the arbiter. So I'm submitting that that is a reasonable test to be imposed at that stage. Now, we should also require both the Justice of the Peace as reviewing officer and the parish court judge to keep a written record of the outcome of the review and the application, which should include the grounds upon which they authorized the detention, if they did so, and that record be made available to the person detained. There should also be a provision, both at the review stage conducted by the Justice of the Peace and the stage of an application before the parish judge, for the review or application to be made ex parte, for the person detained and his representative to be excluded from the hearing, or for certain information to be withheld. And I'm submitting that that is in keeping with the principle of public interest immunity, and recognizes that there may be some information that is so sensitive that it should not be disclosed, and it may risk the very investigation that is being conducted or have other prejudicial implications. And as noted in the before mentioned decision of Ward against Police Service of Northern Ireland, such a provision is lawful and actually inures to the benefit of the person detained. Now, the circumstances in which the judge can exclude the person can be similar to those under the UK Act, which includes that if the judge is satisfied that the evidence on offense would be interfered with or harmed, or the recovery of property would be hindered, then in those circumstances the judge can make a determination to exclude the person detained. I also noted, because this was such an area of concern in terms of the time period, I noted that as it is now, I was not able to find any law that imposes a maximum time period for which a person can be detained without charge before his release. Instead, what I found is that the time is really left to the discretion of a Justice of the Peace or a parish court judge. Because, for example, as I highlighted, Section 22 of the Bail Act provides that where a person who is arrested or detained is not charged within 24 hours, he shall be brought forthwith before a parish judge or Justice of the Peace, who shall order his release or make such other order as the parish judge or Justice of the Peace thinks fit in the circumstances. So it doesn't place any limit, any time limit on the detention. The power to make the order that the judge or the Justice of the Peace thinks fit is wide, and there is really nothing to prevent them from authorizing detention for even longer than 14 days if the circumstances so warrant. Also, when a habeas corpus application is made to a parish judge, I was not able to find any law that imposes a maximum time period for which the judge has to mandate that the person be charged or released. And it really depends on the particular circumstances and the exercise of the judge's discretion. But on the other hand, this proposed legislative amendment places a time limit on the discretion of the parish judge or the Justice of the Peace and sets a maximum time period for which a person can be detained without charge. The proposed amendment restricts the power of the Justice of the Peace to only being able to grant continued detention for a maximum of 7 days, and restricts the power of the parish judge to only being able to grant continued detention for a maximum of 14 days. Those are my submissions.
Thank you. Nee. One thing.
Thank you. The presentation was primarily based on the regime set out in the UK terrorism prevention. In parliamentary research, UK Parliament research paper, it showed that the vast majority, I think 90% of persons who were actually detained under that act up to 2017 were for less than 7 days. So even though I think at various points it was 7, then 14, and 28, in actual fact, the vast majority would not have been detained pre-charge more than 7 days. So the experience has shown that 7 days, even under that Act is probably sufficient pre-charge detention period. The other thing is that if you look at most of these terrorism-related legislation, whether it was I think it was called the Patriot Act in the U.S., which was passed shortly after the 9/11 terrorist incident, and I know there were similar around the same time. There were similar terrorism acts in the UK and in Europe, which provided the motivation for a lot of these pieces of legislation. But there has to be a balance between the national security imperatives and the individual rights. I am very concerned that even although I know in other legislation we've made provision for reviews by JPs or panels of JPs, there's a fair amount of variability, let me just put it euphemistically, across JPs, and I wouldn't want something, a right as important as the liberty of the person, to be dependent on a random JP's discretion. So my own view is that I would prefer that we go to at least a parish judge, and that the period for review, for initial review, if we're going to go ahead with this at all, be within, say, 48 hours, and that the maximum that I would even want to consider, especially given the research done on the UK legislation in practice, is that 7 days would be the maximum that I would want to consider. Mr. Chairman, that is just my initial reaction. But could we also see your presentation? I mean, do you have a written version of this?
I believe it was.
This was circulated earlier?
Yes. I believe it was circulated in February.
There's a police circulation sometime earlier, which I proposed, I think, 7 and 7, and then 14. 7 days initially, and then 7 days by a parish judge, and from 14 days. Oh,
the presentation, a written version of this presentation was circulated some time ago?
From the JSC, there was a JCF circulation document from early in the game.
Right, but it didn't go into this. It didn't go into this level of detail.
Get a copy from Mr. Bond.
I have the original GSF, which dealt with the pretrial detention amongst a host of other things.
This proposed regime presentation was circulated by the clerk on the 13th of February.
On the 13th of February? Yes, my presentation. Yes. As a separate document?
Yes.
To the original?
As a separate to the JCF original proposal.
So this was the original JCF one, which had a blue banner across the top.
Has a blue, but
oh, yours also has a blue.
Well, I didn't see the one. The current one I'm looking at is 21 pages. I believe, or
okay. I think we only have a copy of the old one, which was about 14
pages, right? Mm-hmm. But my own was circulated on February 13.
At a meeting?
No, before a meeting.
Do you have a soft copy? Do we have you circulated a soft copy? You have an extra copy? May I just borrow an extra copy of the
Chairman?
AG?
So by way of comment, you would recall that the issue of pre-charge detention has been raised. First of all, let me express my gratitude to the presenter for the information supplied to the committee. Varying views have been expressed on whether pre-charge detention can be accommodated within the constitutional framework. And the better view that has emerged is that it can be done within the provisions.
You're making this claim against the background. The UK don't have a constitution. They don't have a written constitution.
Human Rights Act, though.
Right.
Not in the same way, but the issues of concern would not be dissimilar in terms of the freedoms and the rights that are protected. The primary issue will have to do with the period of detention, how it is authorized, how it is reviewed. I think those are going to be where some consensus will have to emerge, or further discussion would have to be looked at. But within the challenges that are facing us, the time frame would also have to be looked at in that context. What obtains in the UK, the situation is clearly different from what obtains here, and the building out of the case is something that we may need to hear more from the JCF, not from your side of it, but from the operational side, because that has been the worrying concern. You have reason to suspect that X has committed an offense or may be involved in the commission of offense. The intelligence picks it up very clearly, but you're not yet at the level where the intelligence is going to be translated into evidence for you to lay a charge. And it is important that the person be taken out of the space where they can commit greater acts, they can interfere with witnesses, and the situation becomes worse. You have to guard against people being taken up without proper procedures in place and review. So the question is, who reviews? First of all, for what period can you initially detain before a review is triggered? The better view that is emerging is that the review should not depend on an application from the detainee, but that systemically, by the system, should trigger that review, and you would have to then put in a set of procedures. Question is, who will do that review? And the two views is whether it is done outside of the judicial system, could be done quasi-judicially, or within the court system. And we have some guidance on what would be the better view. Other matters too, while safeguarding the rights, is also looking at the administrative workability of whatever process you put in. And at the end of the day, what is the aim that you're seeking to achieve? So you're not detaining someone infinitely without review, but you are allowing time and space to enable the police to do something in respect of that detainee. That's putting it quite broad.
Mr. Chairman, we heard the same justification during the state of emergency, yet we had dozens of persons detained for months at a time, taken out of the community so it would allow the cases to be built. And at the end of 1 year of state of emergency, the persons had to be released. After 1 year, there was still no cases built against them that they could be charged. So I'm not sure if we've just had an experience where dozens of persons detained for months.
Not dozens.
Eh?
Not dozens.
No, there were dozens. We had, based on the public defender's report, there were at least something like 27 persons who had been detained for in excess of 100 days at the time that she made a presentation. And even up until the end of the detention, I think there were 30-something that had been detained.
20.
well, whatever it is, but some who had been detained for very long periods of time, and they still couldn't put these cases together. So I'm not sure if that justification still stands up, because you had a chance to prove it in St. James last year, and I'm not aware of any of these organized crime cases being put together during that opportunity. So, I understand the theory of it, but I must confess some skepticism. But when we met last time in camera, one of the justifications, another one that was shared, was where you had cases with multiple accused, that just the administrative requirements to deal with, what could be 20 persons, let us say, in a criminal organization, that all of them had to go through the various hearings and what you call it, the ID parades or interviews with their attorneys, etc. That just the very number of the defendants would require some flexibility in allowing time for all this pre-charge investigative, administrative type work, using my words, to be the procedures to be carried out, just to bring the entire group of them to court to be charged, or to complete the process of charging. Now, if you were to say to make some allowance for that, would you then restrict the use of this just for those types of cases where you have multiple accused in a gang situation, and just the numbers that would overwhelm the police in terms of doing it within a very short period of time? Are you contemplating that this extended period of pre-charge detention would only apply to cases under the Anti-Gang legislation, or more technically the Criminal Justice Suppression of Criminal Organizations Act, where you had multiple accused? Or would it be a general, this pre-charge detention would be a generally applicable feature that would then perhaps be more appropriate in a JCF Act or something like that?
Well, initially it was specific to suspects under the Act, but it was... Alethea White, Miss Alethea White.
Right. Just to explain, the Hansard writers are on a rotation.
Okay.
So the new ones that come on wouldn't have caught that earlier.
Before, very well.
Yeah, and I think, Mr. Chairman, some name tags might be very helpful, because where we sit for hours, you sometimes have multiple shifts of Hansard writers.
Right. Initially, our proposal was specific to suspects under this Act, but it wasn't specific to only circumstances where there were multiple offenders. That was just one example of the justification for it. So what we're thinking now is for any suspect under this specific Act. That's the under this specific Act.
So it would be limited to offenses under the Criminal Justice Suppression of Criminal Organizations.
That is the proposal that we have put forward, yes.
Okay, my sense though of what I've in other discussions was that it was desired to use it in a more general way. I'm just remember that last meeting we said we would take the different sets of recommendations, look at the ones which were specific to the anti-gang legislation amendments, look at the ones which might be desirable but would be in a broader amendment to the JSF Act or other legislation. And I'm just trying to understand where this would fall. This is just to explain why I'm going. So the JSF is very clear that this would be specific to offenses under the Criminal Justice Suppression of Criminal Organizations.
Permit me to just seek some clarification from the remarks made by Member Bunting. He referenced the concerns about the number of persons who were detained under the states of public emergency, but who were released later without charge. And I think the concern is a proper one, and it's shared not only by opposition, but by the government. Two, in respect of those for which we have no information, even though we understand that not everyone who was detained would have been charged, because some were detained for their own protection given the dynamics on the ground. But that aside, I just wanted to ask whether, in your view, you're saying that there is or is no place for a regime in law for a pre-charge detention procedure?
Well, I haven't made up my mind yet, but I'm just trying to understand, first of all, the parameters under which it would be used. And what I do know that, in my view, if we're going to use it at all, I don't believe it should exceed 7 days, and I believe certainly within the first 48 hours, it should come before a magistrate for review. But that's just my preliminary. I really want to go back through, now that I have a copy, and I apologize if it had been sent out earlier, but I can't find it in my folder. But now that I have a written copy of the presentation, Mr. Chairman, I'll go through it in more detail by the next meeting, and I'll have a chance to discuss it with my colleagues, and we'll come back with a firm position on it.
I think when looking at it, bear in mind your own comments recently, that looking at charges under anti-gang, the suppression of crime act that we're looking at for review, in those situations, I think certainly for groups charged under criminal justice, Suppression of Criminal Organization Act, you'll have to look at constantly looking at the time. We have to be more flexible on the time than 7 days, and therefore I suggest that in extending it, I agree, rather JP at a certain fairly short time, somebody from judicature should be reviewing it. But I think we should give them greater flexibility in this case, and I would want to keep it within this law for those cases, because those are the ones that have some extraordinary circumstances and can have large numbers. So I'd not want to see the judge tied to a 7-day period, but there should be some restriction, but greater flexibility, given the circumstances and the conditions and the process involved in that, first in detaining and then in going through the investigation. I'm not giving a limit now, but I think to broaden your mind to think of it in that context. If it is used primarily for this part of offenses under this, then there should be some flexibility given to the member of the court to look at the time, and greater flexibility than 7 days. In fairness, coming up to that point, in the case of charges under this, the Suppression of Criminal Organization Act, I'd expect by the time they are detained, there would be a fair amount of information that is near to being converted to evidence. It's a different stage from on the SOE, where we're looking at disrupting and taking out those violence producers. I'd expect once they are detained on a pre-charge detention, there'd be a fair amount of information gathered and quality evidence that you now need to confirm, affirm, or get the security of some of the victims and so forth settled. So it should not take unduly long, but there has to be some flexibility given. Given number involved, it may even be just a matter of fact trying to detain another person in the gang who is maybe off the island. You're going to get him deported, or you're going to find him elsewhere. So I hear your concerns, but I'd like you to consider those in your deliberations on this act.
Chairman, again for clarity, my understanding is that as part of this review, the JCF is recommending that a procedure be included in the revised law for pre-charge detention, and that consideration would be given to initial period of detention, review, and subsequent detention up to a maximum time. And the other question that has arisen is whether there is a place for this pre-charge detention procedure in the general law so that it can be used outside of dealing with suspected gang members.
AG, I put it under, but in going forward, I think we could look at a specific, but once it's constitutionally approved, and it seemed to be that the conditions under the Suppression of Crime Act be given some priority and greater flexibility.
Criminal organization.
Yes, suppression of criminal organization. All right. Any other comments? AG will give it due consideration, and Mr. Bunting, Member Bunting, you'll have some further consultation so we can draw some conclusion later on. All right, there's a second submission here from the ministry, which is to try and bring into context the proposals for the creation of a registry under the Criminal Justice Suppression of Criminal Organization Act, which had to do with the concept of a watch list, which we have been discussing for some time, and at what stage this would chip in and how it would be developed. Mr. Richards.
Thank you, Minister. Good afternoon.
Give your name again for the... So the name is there.
I think I'm fortunate that there's no name tag, so I don't have to repeat myself every time. So just to back up a little bit, Minister, I recall at the last committee meeting there was a request by the AG for us to present to the committee the proposals that were presented in the ZOSO bill to also include the reference to the registry. So I'll just go briefly to remind the committee what the bill, the law reform zones of special operations, zones of special operations, special security and community development measures bill presented in relation to these matters. So recall that the objective of the ZOSO Act is to empower the Prime Minister in council to declare an area as a zone of special operation. And when the ZOSO bill was being presented, there was a proposal to consequentially amend the Anti-Gang Act by including 3 new parts. The declaration of a criminal organization, which we presented earlier to this committee, the control of members of criminal organizations, and Part 1C, which spoke to a register of criminal organizations and control members of criminal organizations. Now, as it relates to Part 1, to Part 1A, Declaration of Criminal Organizations, Clause 2A1 states that the Commissioner of Police may apply to the court for the declaration of a particular organization as a criminal organization for the purposes of the Act. Clause 2A2 states that the application should set out the grounds on which the declaration is being sought. Clause 2C states that the court may make a declaration that the respondent is a criminal organization for the purposes of the Act if the court is satisfied that members of the organization in Jamaica associate for the purpose of organizing, planning, facilitating, supporting, or engaging in criminal activity, and the continued existence of the organization is an unacceptable risk to the safety, welfare, or order of the public. Recall as well that Clause 2E states that such declaration remains in force for a period of 5 years after the day on which it is made, unless sooner revoked or unless renewed. And Clause 2F states that the courts may revoke a declaration or application made by the Commissioner of Police. And I think that sometime before the last meeting, the extract in relation to these clauses were also circulated to the members of the committee. Part 1B, as it relates to control of members of criminal organizations, which we made a presentation earlier as well. Clause 2J states that the Commissioner may apply to the court for a control order for a person. Clause 2J states that the application should state the details sufficient to identify the respondent, the grounds on which the order is being made, the information supporting the grounds. Clause 2K states that on application by the Commissioner of Police, an interim control order may be requested relating to one or more persons specified in the application, pending the hearing and final determination of an application for a control order confirming or confirming with variations an interim control order. Clause 2L states that an interim control order takes effect on the day on which the notice of the order is served, personally on the person to whom it relates. Clauses 2O and 2T state that the control order takes effect once the court confirms the interim control order and the person is either present in court or personally served, and a control order remains in force until it is revoked. Clause 2P states that the court shall hear the application for the control order as expeditiously as possible if satisfied that the person concerned in the special circumstances of the case, he will suffer undue hardship if the hearing of the application for the control order is delayed. Clause 2V states that the Commissioner of Police or the controlled member may appeal to the Court of Appeal within 28 days against a decision of the court in relation to the making of a control order. Clause 2V states that an appeal as of right shall be made within 28 days after the date on which the decision was made unless the Court of Appeal gives leave for it to be made after that time. Clause 2W states that the court may at any time vary or revoke a control order or application by the Commissioner of Police or by the person to whom it is related. And Clause 2X speaks to the consequences of making an interim control order as well as a control order. Part 1C of the bill now speaks to the Register of Criminal Organizations. And you will recall that the Anti-Gang Act consequentially amended Section 54 of the Criminal Justice of the Criminal Justice Administration Act. And Clause 2Y in the bill states that for the better supervision of criminal organizations and controlled members of criminal organizations, a register or registers of all declarations made under Part 1A and Part 1B shall be kept under management of the Commissioner of Police or of such other person and in such place as the minister may appoint, and in such form with such evidence of identity and containing such particulars and subject to such regulations as may from time to time be presented by the minister. Clause 2Z states that in order to make the register complete and to make the supervision over criminals effectual, the superintendents or other head officers of the several prisons and the superintendent of the general penitentiary and the chief of police in every parish shall from time to time make returns to the minister to such person or persons as he may appoint in such manner and at such time, and containing such evidence of identity and other information with respect to persons convicted of crime as the minister may from time to time direct, and all expenses incurred in carrying out this section into effect with sanction of the minister in keeping what the research shall be paid from the consult fund. So owing to the fact that the passage of the Anti-Gang Act consequentially amended the Criminal Justice Administration Act, there is already a provision for a registry. Our only recommendation going forward is that the Minister of National Security be the responsible minister for Part 2A of the Criminal Justice Administration Act.
All right. Just like what you're suggesting, this proposal came out of the law reforms on the special operations, special security, and community development measures bill. But these amendments were proposed for the Suppression of Criminal Organization Act. Am I right? These should be added here so that gangs outside of the zones could be registered. Members, Yes.
I just want to just make sure I understand outside of the technical amendments and suggestions that are here. These amendments to the Criminal Justice Suppression of Criminal Organizations Act would do two things. One, well, three things really. One, a declaration of a criminal organization. And this is not specific to an individual. It would be just saying, for example, the Spanglers Gang is a criminal organization. But without necessarily naming any individual member. Well, I'm just asking to Mr. Richards, you can just nod or give me some indication that I'm understanding it correctly. So that's the first thing. Now, we had earlier, Mr. Chairman, said that the nature of these criminal organizations and the names of them were very fluid. So, you might have the, Jack Mandora gang, and Jack Mandora gets killed, and it now become John Tom gang, but it might be the remnants, the rump of the Jack Mandora gang, and so it's a very fluid thing, and we've seen these names change over time quite frequently. So I'm not sure what this declaration. I don't know of any bank, for example, or financial institution that would accept an account for, a gang, the Ratbat crew. So I'm not sure what the effect of the declaration is going to do. Maybe you could just explain that to me.
Well, I'm sorry to get this thought together, but remember, understand it. Well, I can see where you're going, because gangs is the party we're looking at here, and in fact, in the whole criminal scene, and while they're fluid, there are no monies that might be associated. They have to be something to give, as I say, more specific recognition. But they take 5 names out of 20 and say, led by the following, so that if they vary the leadership, then you can in fact go back and say, so the emerged.
But I just don't know what.
There's a process that I'd expect. I'm inclined that we need to have a process to declare the gangs, but it has to have enough certitude in defining and maintaining definition of the individuals involved.
Right. So short of having some members or leaders to pin to this organization, I'm not sure. Just declaring a name, what's the salutary effect of that declaration?
You'll have to get some names involved somewhere there.
Some members.
Yes,
that's what I'm saying. To just have the name out there without having any members or leaders or other persons.
Spanglers led by, or Jim T crew led by ABCD plus, right? Plus, yes, sorry.
May I think I may be able to bring some clarity. So what was requested was that we looked at some initial consideration that had been put forward but was pulled back for further consideration of declaring someone to be a member of a criminal organization. One of the issues that arose was, what do you do if you have information that someone is a member of a criminal organization, but that information or intelligence is not at the level yet where you could bring them under Section 5 of the Anti-Gang Act? Because it is an offense under the Anti-Gang Act to be part of a criminal organization. That's an offense. So there are a number of alleged gang members that the police have indicated the need to monitor. But between the stage of the suspicion of their membership and actually getting the evidence so they can bring the charge for the offense under the gang, there was a need to monitor them. And this is where the declaration would come in. And there would be a process. And I mean, the concept exists. You hear about a person's been named wanted men and you invite them to come in. And so you would have them declared for certain purposes. And that would allow for monitoring until you get to the stage where you have evidence.
But you've gone further. You've gone further to the membership. I'm just talking about the declaration of the criminal organization.
So that's why I'm saying my recollection is not just the organization, because we recognized, as you have said, that names change and they are not formulated in the kind of way that organizations may be in other jurisdictions, which also went back to what I have as a conceptual difficulty with how the law defines criminal organization, or that concept around it, which then means the gang and all of that. This is still a troubling matter.
AJ, just put my own word in, because I think some way of identifying and monitoring the major criminal gangs, because there are street side gangs, a different way to look at it. I think everybody would desire to have something but has within the law. And I think that's where we're looking, what can we get put in law that will give us the capacity to monitor these gangs, because there's a real problem out there with the violent criminal activity surrounding gangs. And I think that while I see what is put here, I think what we have to examine is how do we get this defined without, how can we create a process, a regime? For example, gangs are named after community. Sometimes I hear Top Road Gang. You go to Top Road, it's a whole community. But Top Road Gang exists and it's a dangerous grouping. Now, how do I, if I'm going to monitor them and declare them a gang and monitor them, maybe it's justified, but how do I get that done in law without breaching the entire?
But I'm saying, forget in law, in practice, how are you going to control an organization which is not a legal entity? It is just a name and a description of an association of the members. So I don't see what is to be gained. You're not going to find a bank account in the name of Top Road Gang, or a house or a piece of property in the name of Top Road Gang. So declaring Top Road Gang is of no value by itself. You have to have some individuals. Here are 3 persons, individuals A, B, and C, who we, by their association, they have formed a criminal organization, whether it has a name or not. And then now you can whether go to a magistrate and get an intercept warrant for their phones or their communication, some kind of monitoring or whatever it is. But it has to be based on some people, not just in an organization that's named.
And we have to have some identity, something to verify the individuals, our members. And I mean, Rob Roddick, you might be able to identify the first 3 to 5, but you'll also have to know if you detain anybody else as part of the gang, you have to show that they're members of, they're associated with the 5. But you have to get the 5 first, and then get the association, I'd expect. No, so I think in practice, it's not difficult. What I'm concerned is how to do it in law. Because generally when you say, Top Road Gang, everybody can tell you, well, Top Road Gang is one gang with one lady in there and about 20 men, and these are the people involved. And they name from Hatchet Man to whatever it is. How do we put that in a legal framework?
Let me try again. My understanding was that what the JCF was saying, they know A, B, and C to be associating together for the purpose of committing crimes. And by whatever name you call them, their association together would be declared right, a criminal organization in keeping with the concept under the anti-gang. And having so declared them, it would allow you to monitor their movement insofar as how they associate together and how they do business severally and jointly, to use another expression out of the law. Right. And once you are named by virtue of your affiliation with each other, because it would have to be at least 3 persons who are known formally or informally, based on the level of intelligence, then it would allow the police to do certain things. And the naming, if you are put as part of that affiliation as a criminal organization, that would stay in place for a certain time. A person who is so named as being an affiliate of that organization could apply to the court for a revocation of that declaration. That is how I understood the concept.
Well,
but I believe it is still quite embryonic from the JCF and needs some further work.
Mr. Richards, the control order that you speak to here, what is, just remind me, what specifically is a control order?
So the control order that we had proposed would, among other things, give the law enforcement the ability to, for example, apply for intercept warrant, possibly curtail movements, and an association with other gang members and other criminals as well.
Yeah, you know, Mr. Chairman, with respect, I don't think these suggestions add anything to police investigative powers. If they have reasonable suspicion now, they can go to get a warrant to do surveillance, electronic surveillance, or the police administratively can use human to monitor and supervise these gangs, or the members specifically. That is already provided for in the Interception of Communications Act and other legislation. I don't think this adds anything, and to the extent now, if the control order extends to the liberty of the person, now again you come back to the constitutional rights of the person, because here now it wouldn't even, this is not pre-charge detention, this is pre-surveillance. This is during the period of surveillance of the person. You're going to restrict who they can associate with, you know, their geographic movements, etc. I don't think that would be constitutional. And you know, so I think from my own view, I don't think this adds anything. Right now, the law provides for surveillance of persons suspected of being involved in criminal activity, and the police can go and get a warrant to intercept their communications. The police can put, you know, undercover officers to do surveillance on them. They can use confidential informants, etc. So, you know, I don't have to exhaust all the existing options, but I don't think this adds anything unless it trespasses on the liberty of the person, and I don't think that we could accept that.
Can I take you back before it's ready to come in? And in terms of, I kind of looking at what is here, I take all 3 together. I think it is what is the objective, and I mean, it is the comments of the AG and both yourselves again, because I think what is viewed and was understood, the criminal gangs are the real perpetrators of significant or high levels of violence and the real threat to the into our institutions, criminal gangs. There are a lot of gangs, but they're real hardcore criminal gangs. And I think what is being sought here is to somehow identify them clearly in law and establish a more detailed system of monitoring them. The surveillance applies to individual. But I think what is looking at is how can you look at your top road gang as a group and establish a rigid monitoring system for them. You may not restrict their movement, but you have the right to put their name at the airport. So when they pass there, somebody will, in fact, the police will be kept abreast of all of this. I'm not sure you can do all of that. No, that's a simple one, but that kind of activity, once they apply for a passport, you know who's applying for the passport. Even if you don't deny them, the knowledge of their activity comes under details of all members of that gang, come under detailed scrutiny, and anybody associated with that grouping. Because look, the individual who is involved in transnational crime, he has somebody who takes his money. And therefore, once you begin to track him, you begin to find out how many times he called the particular accountant, how many times he's dealing with what he's dealing with, what kind of lodgements, etc., etc. That from a layman's point of view, I see happening when you name the criminal organizations. So, in fact, the process is to identify the real major criminal organizations and then establish a more detailed legal procedure of monitoring the entire group and those associated. No.
But Minister, there's a lot of tools on our existing legislation. Proceeds of Crime Act, for example. You can get production orders to go to financial institutions and find, information about transactions, etc.
Once you identify an individual.
Right, but a criminal organization is a collection of individuals. So
yes,
as many of them as you can identify, you can use these investigative powers under various pieces of legislation to do a complete workup on these individuals or on the overall organization through the collection of individuals. Now, what I will say is maybe we're not using it as effectively as we can, or the general police investigators are not using it as effectively as we can. I know there are specialist people, FID, MOCA, they tend to use it more. Maybe CTOC, but the tools are available to the entire GSCF, and it is really for us to ensure that they are aware and that they use these existing, very powerful tools. I mean, somewhere else I saw the recommendation from, I think it was the GSCF of an offense of illicit enrichment. We have an offense of illicit enrichment under the Corruption Prevention Act, and it has been there. I don't know, Corruption Prevention Act was passed over a decade ago, at least. I think it was 2006 or earlier. And we haven't seen, it's restricted to public officers, but I mean, that's tens of thousands of persons. That's the police officers, civil servants, public servants generally. And yet I don't think we've seen more than a handful of illicit enrichment cases brought over the many years since Corruption Prevention Act has been passed. So why would I believe that there would be any greater use of it if it applied to a wider cross-section of people? I don't see any. I think it's really not a want of legislation and not a want of investigative tools provided for in the legislation. Is probably more a want of competent investigators who are not overloaded with cases. It has been pointed out that part of the problem is that even competent investigators in Jamaica who are carrying dozens of cases, it is impossible for them to be effective when one of their cases would have a team of 10 or 15 persons working it in other jurisdictions. So part of it is they're just overloaded, and you just need more investigators, perhaps more training as well, so that they can use a wider range of tools available in these more sort of cases which require some kind of forensic investigation beyond just the scene of crime type, but forensic accounting, forensic auditing, those sorts of skills which the legislation now provides for.
Chairman, in an earlier session of the committee, I sought clarity on two levels. At the investigative stage, what were the limitations that the police felt were hampering the proper investigation of criminal organization? And at the other stage, from the prosecution side, in presenting the evidence that would secure conviction under the Act. I'm still not as clear as I would like to be at this stage of deliberation. The other thing that I'm wondering about, and Member Bunting's intervention prompted my thought. It appears to me, it is true that there exists a number of very powerful tools in various pieces of legislation. And I wonder if in investigating criminal organizations in accordance with the scheme of the law, there is a feeling within the JCF that the tools that exist elsewhere are only applicable under those laws and are not of general application, which would bring into sharp focus the issue he raised about training and understanding the menu of tools available and from which you can pull. And it's a matter that we have to probe deeply on, because we continue to pass laws and the statute books are not short. And we have not been able to utilize to the point where we are now talking about a suite of powers and pulling from all the different places where we have provided these powers under one umbrella, because there seemed to be something missing somewhere of an understanding of where you look and when you find, how you use. And I think that's a big part of what is crippling us. But I don't necessarily know that more laws and more acts by themselves is going to help us along without our taking stock. Now, it is true that some of what we have in different places may need to be brought under the general application. So you know that as a police officer investigating whatever kind, it is a tool that you can reach for and use across a wide area. But I feel that in spite of all the time we have spent here, I'm certainly not as clear as I would like to be about what are the real challenges and difficulties. It is true that the law needs to be revised, and as defensive as Member Bunting is of the law, having piloted it, and understandably so, took ownership of it, I still have some conceptual difficulties with it. I mean, I will understand his stance, and a minister with then portfolio or current portfolio responsibility will feel. But the truth is that, and I don't know that we have really gotten to the meat of that matter, but it may just be my personal limitations.
Let's just say before Member comment that since there are a number of cases before the court, though, we may begin to see what are the opportunities and limitations, and a couple of big cases under the current legislation stance. It may be, however, that the point you make that we don't want too many legislation, but I think since we are parliamentarians here, I think there are two aspects to it. One, there may be value because of the priority given to gangs of bringing a suite of some of the activities to one suite. That I don't know, and that will be advised by the legal minds, right? That there could be value bringing it on this particular piece of legislation for, greater clarity. But you also raised the issue of looking at our investigative team and how we organize them. It's a different matter in a different setting we'll have to look at. Because if you begin to get into the kind of specialized skills that you require, we pass laws, how we provided the police force with that kind of policy direction to begin to ensure that we train people who can deal with the forensic audit, forensic investigative beyond the crime scene, and treat them properly as well, because they become specialized professionals in their own right.
Mr. Chairman, thank you for that observation, because that was the point that I wanted to make. In fact, it is frustrating and demoralizing when you keep on passing legislation which is not implemented. and I do think we have to focus on the implementation. From about the second or third sitting we had, it was clear that what was missing is that a lack of a holistic view of the suite of measures, the suite of legislation which was available to be used in certain circumstances. And perhaps what you're saying is absolutely correct. If we could pull them, since this is such an important legislation and it's so current in terms of the problems that Jamaica faces, if we could probably pull them together in a way that would provide the investigators and the prosecutors with everything under one framework. But I also want to ask, Mr. Chairman, if Mr. Richards could explain in relation to clause 2Z, I want to understand, if he could assist me, the reasoning behind it and exactly how he sees that this would work. That is at, are you with me, Mr. Richards? Yes. Part 2Z, which speaks about making the register complete. I just wanted to get an understanding of how you see it operating, the purpose, how you see it serving a purpose within the context of our discussion.
Again, while Mr. Richards tries to figure it out. Again, Mr. Chairman, this just seems to be an administrative activity. If these people are already in the prisons, to categorize them and make any report on them and keep any register of them is already within the, is provided for under the Corrections Act. So, I mean, I'm not sure what further powers the Commissioner of Corrections
I was thinking of this
need.
for the registry, like what's coming up in your Sexual Offenders Act, where you keep a ongoing month of certain people because they are known to be gangsters. And part of the problem, the question you raised earlier, that a gang tend to be able to a little bit operate like an amoeba, like a head. You cut off, you disrupt the head, and suddenly they grow 10 new ones, and that may allow you to. This part of the legislation would have been designed to create that kind of watch list. So, like the gangsters tend to be serious.
Right, but all I'm saying,
Mr. Chairman, the current corrections
these persons are already in the correctional services, which means they're convicts.
No, but once they come out, I mean, my understanding of how the sexual offender register will.
No, but the Criminal Records Office would already have all the details of these people, from their fingerprints, the offenses they've been convicted of. Everything is already today.
Again, I'm looking, you have been there before
under
me.
Existing legislation is available in the Criminal Records Office.
What I'm seeing here, and I think this one I can see some value, is to separate those members, those criminals who are gangsters, who are now out, that you maintain a separate registry to identify them and mount them, basically. Because I find gangsters, they will go to prison for 10 years and they come back and they restart the very operation that even a different name. So you sent me to prison, or your brother sent me to prison, he now dead, but they're going to kill you. Right? That happens, and I'm not saying that anecdotally.
I'm not arguing against the need to monitor or whatever, but I'm saying these powers are already available under existing legislation, so and the records are in the Criminal Records Office, between the Criminal Records Office and the Commission of Corrections.
So you could extract this.
You just need to extract this information. Today, you don't need any new legislation to do this.
So putting this in a separate schedule, you don't need legislation.
I don't think this I think this is just an administrative
Chairman,
decision.
Member Bunting, I hear the concern, but I think various laws have provided for registers, and the registers have not been kept up to date, or have been kept in a way. So what I understand the provision, and I'm not saying what I understand the provision to be targeted, is that you will have persons who are convicted in different parts of the island. And somebody keeps that record and would be placed under duty to ensure that parish by parish, chief of police in every parish, that information in a timely way is sent forward so that the register can be updated. That is my understanding of it. As to whether it is articulated as clearly or whether it needs to go in by way of this law is another matter. But to the extent that you make provision for a register, there has to be a process by which those who have the information supply it to the keeper of the register, and that it is kept up to date from time to time. So it's not something to laugh away at, however awkwardly it may be stated.
No, what I'm saying is,
I'm trying to get an idea.
Mr. Chairman, is that this already exists. If you drive on Duke Street any morning about 10 o'clock in front of the Criminal Records Office, you see a line on the sidewalk. Everybody know who is going to be an operator of a public passenger vehicle, if you're going to work in the BPO sector, if you're going to work in financial institutions. Other entities require police certificates. What does this police certificate say? It says that you don't have a criminal record, and it don't matter whether you got it in Savlamar or in St. Anne. It is a centralized database, and even if persons have changed their name, when you go there and you put your fingerprints, it will pick up from their electronic database, which we spent hundreds of millions over the years to build this database and to maintain it. And it is there already. It exists. We don't have to reinvent the wheel. And if you want to separate the persons who were convicted of gang offenses or murder or drug dealing, that is mainly an interrogation of the database. That you don't require any new legislation.
AG, I like your comment before you come in.
You know, different things are being said, and we have to just clarify.
Clarify something for me as well in terms of as you speak, because my understanding, the registry, the data records have all of the convicts there. My understanding I was getting from this registry is that some that were very easily available, not just at the point of registration, but this is a registry of known convicted gangsters who may move across the island, and I don't know what he did, but say every police superintendent have that record available when the man goes to not the spot to drive a public vehicle, whatever he do, whenever he moves, whatever he does in a part of your mountain.
Just by way of reminder, though, that this was an ancillary provision which was premised on a declaration of the criminal organization being made, and then those who are so declared would form part of a register. So let's not get ahead of ourselves and confuse. But I see has been, no, not Richards, superintendent has been.
So, Anthony McLaughlin.
Yes.
Right, and Madam AG is correct, because when you look at the 19 geographic divisions that we have in Jamaica, if somebody commits a crime in Montego Bay and moves to Kingston, the register is kept manually, right? But we are in the process of trying to get it electronic. So it's going to be difficult to get that information, speedily. So that register is really important. Now, until we can get it electronically, where we can just go on the computer and we type in a name and we get it up, we have to keep that register manually. So it is important.
No, I think, again, we have to be clear. I think there are some assumptions being made which do not hold. And assumptions that systemically, once something happens, automatically the happening is notified on the other end of the island. But if registers are being kept manually, and I'm not talking about just what is proposed, then some way the information has to be found. To share a case with you, I recently had a constituent who called me to say that he went for his police record in order to satisfy the requirements for the farm work program, got a clean record. He knew he had a matter in the St. Elizabeth Parish Court. The matter had terminated in his favor. But the certificate of acquittal had not been sent to the records office. But when his fingerprint was taken, that was sent, and it is recorded that the matter was pending against him. The persons in St. Elizabeth had not discharged their duties to transmit the information, and there was a problem in between. So
I need to do a check. The judge,
no, but
I don't know if the judge discharged. She discharged.
Yeah, but that is a case of a false positive. But you're making my point, Minister or Mr. Chairman. We invested hundreds of millions in an automated fingerprint and palm identification system years ago. It has hundreds of thousands of records in the database, both of persons convicted and of persons charged. It's two separate partition. There's a partition within the database. And if the persons are acquitted or the case for whatever reason is dismissed, they're supposed to be removed from that charging section. You know, the specific example is where somebody, the paperwork has not yet caught up with the reality. They have not sent that into the criminal records office. But, you know, again, it comes to, we have a very powerful tool. In fact, I'm surprised because we even purchased mobile units that when persons went on operations, when police went on operations, and they detained persons in the field, they did not have to take them back to a police station to do the processing. They could check them right in the field if they suspected that it was a wanted person and they needed to confirm the identity. So we've had the database, we've had the technology. Now, maybe we have not been using it routinely, and that's another matter. But those are administrative arrangements which need to be made. We don't need to pass any more legislation to do that.
When so many things are said and you have to disaggregate the information, let's go back to the concept. Insofar as the question that arose on the proposal is what was the clause intended to achieve. Take it away from a proposal to declare organizations, criminal organization, and then to keep a register of those who have been declared, and put it in the context where you keep a register. What I understand the essence of the recommendation to be is that whomever has the information across the many parishes should be under duty, obligation to transmit the information to where it is being kept centrally so that you may have an accurate and complete register at any given time. As a matter of concept, it is unassailable. Whether an automated system has been invested in and should exist is a separate issue. When your automated system is working properly and all the dots are connected, once you enter at one point, that should transmit. The impression I am getting insofar as the keeping of register, that is not yet where we are for whatever reason, and we must investigate to the extent that so much money was spent on it, because it makes no sense. You provide for automated system, and then years later you're hearing we're back to square one, and it is impacting people's lives in a real way. So there are many questions to be answered, but placing a duty on anyone, especially police officers who have information that should be fed into a registry, is a concept that makes sense. Can be done administratively. If the law already provides for it, you may not need to re-legislate. But that is my understanding of the concept of it. Now, question has been raised, properly so, as to what is the need for the declaration of criminal organization. What more is it intended to achieve when you look on the menu of tools available? So it does not appear that, well, insofar as the members' views are recorded and shared by anyone else, that recommendation would be put forward as something for acceptance without more, without answering what is it going to further, you know, can the existing tools be used to achieve the same outcome that you're seeking? Because we're not reviewing for the sake of reviewing to pluck everything and put it there. We're to emerge with a set of recommendations that will cause a review of the bill so that it can be implemented and enforced to get to the results of putting those who associate together for criminal activities where they truly belong.
Bonding, you want to?
Minister, maybe I can just give the benefit of the time I've spent in this area, because I'm surprised that both the AG and a member of the JSF doesn't seem to be aware of this. There is a unit called, I believe, the Information, Communication and Technology Division up at the Commissioner's office. They have these handheld devices. I think they're called Morpho Rapid. And the FLA also has the same technology that they can check persons' fingerprints when they're applying for.
FLA is doing it, and they're causing us a lot of problems.
Right, the FLA is doing it. And the GSCF has the same ability. And as I said, we got many of these small handheld devices that would require that persons on operation in the field would not have to scrape up a whole heap of people who they believed might be suspects but couldn't confirm in the field, using this handheld device, which was called a Morpho Rapid, which could check their fingerprints remotely. And the technology is all there. It's in a centralized database. Now, it is one of the biggest, although we spent a lot of money on it, it's one of the biggest revenue sources for the GSCF and for the government. I believe there's a revenue sharing arrangement. Every time somebody pays for a police certificate, that is the system that they use to check the database of not just convictions, but of charges. Even persons who are on charge are in that database. And it is there now. We spent a lot of money putting it in place, and we just need to use it, and it's maintained. And if you go to, I forget what number Duke Street, where the criminal records office is, if you're, it's 32 or something like that. Yeah, somewhere around there, 34.
That's 34.
Right. You will see hundreds of persons down there every morning. It look like it's next to the visa applicants. You see the line going up the sidewalk of Duke Street.
There is issue,
right.
Remember.
Well, it's technically criminal records office, but they call it police. That's where you go for the police record. And all that information is there centrally. It can be accessed remotely from any part of Jamaica. It records convictions and any charge that required a fingerprint to be taken from every police division across Jamaica. So these are things that, you know, I think we need to be very careful about thinking we need more legislation. We need just better utilization of the existing technology. And a lot of this is really administrative and procedural rather than requiring new legislation.
But sir, I am quite aware of the handheld devices, but it's not, I am at CTOC. If I pick up a gangster, say in downtown Kingston, and I want to know if that gangster is, well, if that person is a gangster, unless I call the other divisions, and sometimes all you get from that person is an alias. We do not have the handheld device to fingerprint that person. I would have to make an application now to the superintendent in charge of CRO.
Sorry, you said you are aware of the device, but you are not equipped with it.
We are not equipped with it. It's not enough for each of us to get one, or each of the sections to get one. Right?
Then the solution is to buy some more.
Right. It's a discussion the other day, because although they're there, you know, we know that the FLA has them and probably utilize them much more than us, which is a reality. So I go back to it that, you know, administratively we can do more. But in terms of the registry, you know, that wouldn't significantly help us, you know, if we want real-time information on the status of an individual, whether or not that person is a gangster.
You still need something, an electronic device to do the real-time. Even if which I'm intending. Look, you can isolate all the gang members in one schedule. It's a computerized thing.
Right,
so
exactly.
you can get it quickly rather than going to 20,000 names. You go to 10,000, which is easier. But it would not seem to require no legislation. It could seem just some regulation that could be put in place by the
Mr. Chairman,
Mr. Richards,
you have 20 billion in your capital budget this year. 20 billion. A little piece of it can buy. I told the chairman I was very envious of him. I had less than 2 billion in my time per year. He has in 1 year more than, many times what I had for the 4 years I was there. But putting that aside, these are not, relatively speaking, these are not that expensive. And every police division should have 10 or 20 of them.
I'm with you on that. I'm totally with you because, as I said, part of what we, and I'm glad these have come up, because what is really happening is that we have taken an opportunity from this side of the House, which is the legislative side, to look at, I said, how we implement legislation, because I think part of what we do is focus on passing the legislation and take very little time to look at how we execute. And it's not a matter that the police is inefficient. We just didn't look at how best to provide them with the tools to use the legislation, and not only in terms of buying equipment, but there may have been some kind of orientation of the investigators who are involved in this kind of the CTOC members, the CIB senior leaders who have to now begin to pull all of this thing together. It literally is a whole suite of legislation to pull together to work together.
And these things, Mr. Chairman, are force multipliers. It makes their job much more efficient. Just think of if you had this handheld device, which is about the size of a smartphone, and you could just confirm the identity in the field, say in a minute, rather than having to take this person back to a police station.
We approved it for the mobile patrol sometime, and I don't think they're ever giving them. We're looking at the kind of cars they kind of in.
Exactly. You need vehicle, you need to lock up to put them in all these sorts of
AG
things.
and then Mr. Richards.
Mr. Richards first, Chairman,
Richards,
and then I will.
and then AG.
Thank you, AG. Minister, I just wanted to make sure that there's a recollection that the law, the anti-gang as it is, already provides for a register. Our recommendation was really that section of the law that speaks to register, because the Anti-Gang Act consequentially amended the Criminal Justice Administration Act, and it says that any person who has been convicted of an offense under the Anti-Gang Act is being considered for designation as a restricted person. So the law as it is already provides for the register. What we're proposing is that the register be the responsibility of the Minister of National Security. The Minister of Justice.
Yeah, that's the one.
Just that part, Minister.
No, but you have to understand why the issue arose in the first place, and it went back to who had responsibility for the Criminal Justice Administration Act. But that's by way of history lesson. Chairman, so then the recommendation is that the provision in relation to the register be amended to make the keeping of the register the responsibility of the Minister of National Security, and that obligations be placed on the various police heads across to supply information for the keeping of the register.
Right, AG. Operationally now the JSF has responsibility for the register, but the administration is with the Ministry of Justice, Minister of Justice.
It's a recommendation put forward for
so
consideration.
The administration moved to the Ministry of National Security as well.
Just in relation to this part of the act.
Mr. Chairman, I just said there were good reasons why I believe it falls under the justice, and it has to do with things like, for example, expungement, all those sorts of things which operationally fall under the Ministry of Justice. So I don't think we can just look at it from one side.
Look at it broadly.
Yeah,
I think there could be value in the Minister of National Security having some responsibility for the registered gang members. That will be extracting a schedule.
I mean, but what I'm saying, it can be done administratively.
Yeah.
If you want to see who are all the persons
I'm hearing loud and clear on that.
Yeah, convicted of anti-gang offenses, you just do that search in the database and extract them.
So I benefit from your experience.
Chairman, so this part of the discussion with a recommendation for consideration to be given properly. If we conclude that, I want to return to... No, it's not stubborn. No, I'm moving it along. Chairman, I want to return, to the extent that we have finished with that issue, I want to return to the monitoring issue that had detained us earlier. And perhaps the recommendation ought to be that the schedule be amended to include the POCA, the Proceeds of Crime Act. And then those tools that are under the Proceeds of Crime Act would apply in this case.
So where are we? That's all
the elements of the POCA bill be brought in.
Earlier, the discussion centered on the tools that were available and whether additional tools would be required, and reference was made to some of those tools that were under the POCA regime. So we could look at a proposal to amend the schedule to make reference to the POCA, and then the tools on the POCA monitoring would become applicable in the investigation.
Minister, just to say, we had already signed those orders and it is being done. Yeah.
I didn't get... That's correct. We do have some new orders. Yes, the legal reform department did make a suggestion, and I think they were drafted, and we are bringing that on the POCA. Yeah.
Signing of the order, but it's the amendment to the schedule to reference the Proceeds of Crime Act. It's two different things from signing the order, or is it? I don't know what you're referring to.
It could be. I'll get it to your AG, because
I'm not clear what the order provides for. Could you just be a little more expansive in saying what the order provides for?
It came from this meeting, and the legal reform made recommendations.
To amend the POCA schedule to include offences under the anti-gang legislation.
And that doesn't require any affirmative resolution or negative resolution of part?
It will be brought here.
Yes, it does. It will be brought.
It's in process, but it hasn't come to Parliament.
Yeah, it came from, in fact, legal reform, because of CPC actually suggested and brought it up, and they were done, and they are going through the mill now to be brought here for affirmative resolution.
You're saying that that would not require an amendment to the schedule to include POCA under the anti-gang? Right, so it's the POCA schedule that would have to be amended to include the anti-gang in order for the provisions of the POCA to apply in the investigation.
And that's being done now on the schedule.
So that we can be clear, right?
So we should be able to bring that here pretty soon. Because I've been gone.
Sorry, Mr. Chairman, if I might add, the schedule to POCA that I understand is being amended is the schedule that outlines the different offenses that are considered criminal lifestyle offenses under the Proceeds of Crime Act. Criminal lifestyle offenses is relevant to when you're applying for a forfeiture or pecuniary penalty order after somebody is already convicted. So I don't believe amending the schedule will automatically enable the police to apply for the investigative orders that Member Bunting was referring to, because those investigative orders can only be obtained in certain circumstances. I don't believe the amendment will...
The production orders from the banks, where the banks have to produce information.
The amendment will not apply to the
it's two different things. One has to do with evidence. It is assumed that if you have a conviction of this type of offense, it is prima facie evidence of a criminal lifestyle. And therefore you are subject to your assets are subject to forfeiture unless you can prove that you got them from legitimate sources. That is the schedule that has been amended to include anti-gang convictions on anti-gang offenses as prima facie evidence of a criminal lifestyle.
But would, as useful as that may be, would that address the issue in respect of the investigation and the monitoring? Because it's two different things we're talking about.
No, I don't believe the investigative tools are subject to they're not restricted once you're investigating a particular type of offense.
No, they are restricted. You have to be investigating in a money laundering offense and show that you have reasonable cause to believe that the person has committed a money laundering offense, or that they have, or you're investigating a forfeiture
Look on the
offense,
provision.
right? Or you're investigating a forfeiture, doing a forfeiture investigation, or that you're doing a civil recovery investigation. It's
or
three
financing of
circumstances.
terrorism, I believe, is also.
Not for-
it might be under the financing of terrorism prevention
But
act.
for PROCA, there are three investigations that you can obtain the investigative orders for: money laundering, forfeiture, and civil recovery.
Unless and until I look at it, I'm not. I'll just have to come.
I'll get them to get your chamber to take a look at it. We can get before we bring it down.
But one thing you know, any criminal organization is going to be involved in money laundering. So because they have to deal with the proceeds of the crime. So yeah, I don't think that is going to be a significant hurdle for investigators to cross in terms of using those investigative tools under the Criminal Justice Suppression of Criminal Organizations Act.
The actual amendment to the schedule proposed some legal reform. I think Mr. Bailey was here and proposes that we go that route to satisfy this requirement actually. So kind of, it's the drafting is complete now, Miss. I know signed up. You tell me.
Yes,
you
sir.
guys.
The resolutions were done by the CPC and sent over, and you had actually signed them. So they have to come here.
Where are they in between my office and here now? No, I said, so they're still in my office? They shouldn't be. All right. I'll check on it and I'll have the AG take a look at it as well. All right. I think we have done a good evening's work. It's now 4:30, approximately. We'll look at the next meeting a little bit too. We have no more submissions, but you'll now have to pull the matrix. was trying to set that date. I think we should have the full matrix suggestion and we would have some consultation before. So looking at 2 weeks from now, how we, AG? Yeah. Adopt the minutes and all of that. So 2 weeks would be a good time to give everybody a chance to. Huh? What do you? Next week could be a bit, sounds a little bit short. So we're looking at then Wednesday the 10th?
Third. What about the third? The third is something?
Boy,
Oh, you have something on the third?
I'm a sector on the 9th. I love it.
Okay, so.
It's a bit far, but we're looking at the 10th. Then all the minutes can be circulated, get a chance to read. We confirm the minutes, and then we have the matrix ready for some decision. Huh? Can we? My experienced, learned colleagues there, AG. We're looking then, if we cannot do it on the 27th, which is the day before the 28th. You could do it on the 27th. Yeah. Okay. The 27th I'm looking at. Yeah, we can meet.
Just the sectoral debate starts in April. Okay,
Yeah,
so
April
27th
9th.
of March would still be before that. So we'll have it in the afternoon.
And I'd prefer to have it. It's just that. Oh, what is this in the afternoon here? And they take long? Oh.
There's already something on 20th.
Scheduled for the Wednesday afternoon of the 27th. Could we trust a morning meeting to be near to the end of it?
Yeah. 10, we could do at 10 o'clock.
All right, 10 o'clock Wednesday, 27th. We get the minutes and we look at the matrix now to see how we move from there. All right? Okay. The 27th. And I would, you could, yeah. I'll resend the minutes because member Bunting would have missed some of them anyway. So just resend the minutes. The minutes. You sent all of them? Okay. All right. We have them. And then I would reserve one day after
I joined the committee late, so I would have missed the first. So, but you sent all the back ones for me. Thank you. And
then we'll go back to another one on the 10th. We need at least 2. Now, how many more meetings now? You're the experienced one in the legislation. Roy. How many more meetings we'll get before we finish our section here? Another. All right, that's Thursday the 11th. You'll be available, AG? The 11th or the? Oh, you'll be off.
Sir, remember that Thursdays MPs don't normally want to meet on Thursday.
All right, we stay with the 10th, the morning again, and we try and tidy up. I'll take no more. Two meetings set. All right, let me thank everybody for the evening. I think we had a very productive evening. And my apologies again, I came late, but my many caps caught me. AG?
Just for the record, you would see that at the last meeting I indicated that the government had made a commitment to have a meeting with the opposition to discuss some of the related security meetings. Just to indicate that that meeting has been held, for the record.
Very good. You got adjourned until, eh?
You sure want me to put it as matters arising?
No, just note it. Hmm?